case that's set for argument here this morning is case number 21CA011799, State Automobile Mutual Insurance Company versus Edgar Rowe. Parties are represented by counsel. The panel, as you can see, is Judge Carr, Judge Callahan, and myself. Each of you will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. If you're going to do that, let me know because I'll be keeping track of time. And I'll apologize in advance. I may interrupt you to let you know that you're getting close to that rebuttal time. We have read the briefs and are prepared to proceed if you are. So let me just start by asking, will you be reserving time, Attorney Carr?
Yes, Your Honor. I'd like to reserve 2 minutes for rebuttal on my cross appeal.
All right. Attorney Gallagher, go ahead.
Thank you, Your Honor. I'd like to reserve 3 minutes of rebuttal time as well on my appeal.
All right. Okay. Attorney Gallagher, do you want to go ahead and get started then?
Yes, sir. If it please the court, we are here on an appeal from the trial court's ruling on August 27, 2021, after a review of claims file materials for purposes of privilege. The court ordered at a hearing that was held April 14, 2021, that we produce claim file materials to the court for an in-camera inspection along with a privilege log. We did so as the court ordered us to do, and following that, on August 27, 2021, the court issued an order. And the first thing the court indicated was the court finds no legal basis for said file being discoverable by plaintiff. But then the court went on to rule that the court allows for an eyes-only review by plaintiff's counsel. We are appealing from that portion of the ruling. And our position is that once material has been designated as being privileged and confidential, and once the court agrees that there is, quote, no legal basis for anyone being allowed to look at it, it is in fact error for the court to then order that opposing counsel be allowed to look at everything, and in doing so actually without restriction. The case law out there indicates that a ruling such as this, where allegedly privileged material has been ordered to be produced, is final and appealable. And that's the DeVito versus Grange case out of the 8th District, Bukinas versus State Farm out of the 2nd Appellate District, Garg versus State Auto out of the 2nd. So it is final appealable, and the thing about this is it's error on its face. I mean, there's no appeal from the first part of it. The court finds no legal basis for the file being discoverable. There's no ability to appeal from a finding that material is not discoverable. There's case law even out of the 9th District on that issue. And I would cite to the Bowers versus Craven decision out of the 9th District in that regard. The only thing that's appealable is whether a trial court finding that there's no legal basis for opposing counsel to be able to see materials allows the court, then orders that a party produce those to the other side. Our position is that that is error on its face. When it comes to the cross appeal filed by the Rowes, again, I would cite to Bowers versus Craven that says that the initial part of this decision, which indicates that there's no legal basis for the file being discoverable, is not a final appealable order. There's nothing in Ohio law or case law that would allow him to do so. And there's in fact 9th Appellate District authority saying that he cannot do so. There's also this cases I cited, Miklovic versus Shear out of the 5th Appellate District, and Diacentis versus Margello out of the 10th to that same effect. So we object, and we have put in our briefs that we object to any cross appeal by the Rowes as to this particular ruling. Their part of it is not appealable. Our part of it is. When it comes to just a general history of this matter, this case arose out of a drowning incident that occurred October 5, 2016, at property that the Rowes owned but never lived at. Neither of those things are in dispute. Their daughter ran a babysitting operation out of the house. The daughter allowed 3 2-year-olds to remain unsupervised in the backyard for a period of long enough for them to climb up into an above ground pool. One child drowned. Another child sustained brain damage. A third child actually crawled back out of the pool and came back in the house all wet, which is the only reason she knew they were in there. The Rowes were sued. The Rowes turned a claim into State Auto. State Auto issued a denial on July 12, 2017. So a drowning was October 5, 2016. The drowning or the denial was July 12th, 2017, about 9 months later. And the reason for that is that the State Auto homeowners policy in question says that in order for there to be homeowners coverage for you, the house has to qualify as a residence premises, meaning you have to live there at some point in time. The Rowes were deposed. When they were deposed, they admitted they'd never lived in the house. They'd owned it for 10 years or so and had never lived in there whatsoever. In addition to that, the policy says that there is no coverage for a business being operated out of a house. You need to get a different kind of policy for something like that. And there's case law as to both issues, holding that homeowners policies don't apply if the people don't live there, and homeowners policies don't apply to businesses operated out of a household. And that was the basis for the denial that State Auto issued on July 12th, 2017. Remarkably, in addition to the policy language, the Rowes agent, insurance agent, wrote them 2 letters a year for 8, 9 years. And in each one of those letters, they warned, are you operating any kind of a babysitting service? If there is a babysitting service going on, then you need to tell us about it, because there's very limited, if any, coverage for that type of a thing. The Rowes admitted that they got every one of the letters, and they admitted that they knew their daughter was operating a daycare out of their house. And they admitted that despite all that, they never told anyone.
Counsel, the allegation is, though, that that State Auto knew they were operating
I heard
a daycare center and could have canceled their policy.
I read that in the briefs, Your Honor, but I didn't see that they pointed anything in the record, and there isn't anything in the record which indicates that. That's a bare-boned allegation that State Auto knew anything like that. So no, there's no citation to the record as is required, and it's not in the record. But I agree. I was surprised to read that as well. So no, the Rowes were asked specifically whether they ever told their agent or whether they ever told State Auto that there was a daycare operation being run out of that house. And in their deposition, they both indicated, no, we never told anyone. We didn't tell our agent. We didn't tell State Auto. So I read that in the briefs. I'm surprised to read it. There's nothing in there, and there's no citation to it. The Rowes depositions were filed of record in record number 90. There's a list of exhibits there. And in their deposition transcripts, they will specifically disavow telling anybody about the daycare operation. So it's just not true. Anyway, the Rowes, in fact, got sued along with their daughter for wrongful death by the family of the one child who had drowned. And when they were sued, State Auto filed a deck action to determine that there was, in fact, no coverage. That's how this litigation that we have here before you today got started. The plaintiffs came back and they sued for fraud, claiming there's actually 2 policies, one for the house where the drowning occurred and another for the house where the Rowes lived, and that State Auto was hiding it. When we deposed the Rowes, they admitted that no, they actually had a State Auto policy some years before the drowning, but they canceled it. They knew they canceled it. They changed to Grange Insurance Company, and they were meeting with the Grange agent once a year about that. So there never was a second policy that was in effect from State Auto. It was on that basis that the trial court at the April 14, 2021 hearing ruled summary judgment in favor of State Auto on the fraud claim. The only thing left is the DEC action and the alleged bad faith by State Auto for denying the claim. When it comes to the DEC action, there's really no disputed any facts. The policy says if you don't live there, it's not a residence premises based on the letter of the policy. The Rowes admit they never, ever, ever lived in the premises, and so that clause applies. The policy also says there's no coverage for a business being operated out of the house, regardless of who is operating it. And there's no question that there was, in fact, a business that is a daycare operation being operated out of that house. That's not opposed either. We argued that a summary judgment motion on the coverage issue on April 14, 2021. The court declined to rule on the coverage summary judgment motion until further discovery was allowed of the claims handling. We urged the court that has nothing to do with whether there is or isn't coverage. But the court ordered that anyway, and at that point in time ordered the in-camera inspection of the withheld claims file documents, which is why we're here today. There was some indication by the plaintiffs that paying the claim doesn't mean you're not in bad faith. Just, again, that's nothing in the record about that other than the depositions from the Rowes. State Auto actually paid its full policy limits at some point before that death claim went to trial. They got a release for both Rowes and also for their daughter for both the wrongful death claim and the brain damaged child claim. State Farm is not claiming that disavows them of bad faith in this case. It's not an issue. State Auto is claiming that it's not in bad faith because it had a reasonable basis to question coverage. And in fact, it's accurate that there actually never was any coverage in this case. So the main question before the court today, and what is unfortunately a fairly convoluted procedural history, is this. The fraud claim is gone. The coverage issue doesn't have any question in material fact, but the court wanted to somehow address the bad faith claim before ruling on the coverage claim. And in so doing said, give me all the materials that from the claims file that you withheld, and I'll rule on whether the plaintiff should get it. And after doing that, the court found as a matter of law that there, quote, is no legal basis for said file being discoverable by plaintiff, which again is not an appealable order, but then ordered me to produce that file to plaintiff's counsel for an eyes-only review, despite the fact that there's no legal basis for him being allowed to do so. And that, unfortunately, is error as a matter of law on its face.
You are at 3 minutes right now, Attorney.
I think it's probably a good time to quit. I would just say one other thing. In addition to ordering the court ordering me to turn it over for eyes only, it doesn't restrict anything as to what the plaintiff's counsel can do with it once he reads it. And there's case law I cited to you indicating that also is error. It doesn't say he can't share it with his client, can't share it with experts, can't use it in depositions, can't use it at trial. It just says that he's allowed to look at it with no restriction. With that, I'll reserve my time.
All right, you'll have 2 minutes, 32 seconds. Attorney Carr, I misspoke. I'm sorry. We'll have 15 minutes from you. You're the cross appellant on this. So you'll have a straight 15 minutes and then we'll hear from Attorney Gallagher for his 232. So I apologize for that confusion.
Your Honor, am I able to reserve any time for rebuttal on the cross appeal, or do you just want to handle it straight?
No, you just handle it straight. That's
Okay.
why I'm apologizing for if I think I might have confused you there. So sorry about that.
No need. Thank you. I'm clear now.
Okay.
All right. May I proceed?
Yes, please do.
Thank you, Your Honor. May it please the court. I guess first I should clear up, since this is a public proceeding, that Attorney Carr is not related to any member of the panel, despite the similarity of the names. So, I want to clear that at the outset. I think everybody here understands that, but there may be some observers in the public who might wonder.
Thank you for that.
Thank you, Your Honor. I'd like to address the facts first because there seemed to be some confusion. I heard here about a statement in the briefs that the insurance company, State Auto, was aware that there was a business operated by an insured. That's not correct. In fact, I think the record is clear that my clients were not involved in the babysitting business. And Etta Rowe, Mrs. Rowe, testified that she was not aware that her daughter was watching children for money. She was aware that her daughter was watching children.
Well, I'm going to jump in because
Yes, Your Honor.
I know I read that in the brief.
I will
So
tell
that
you
was a
what
mistake in the brief.
If it was there, it was a mistake, Your Honor. I'll tell you what the insurance company was aware of. They were aware that the insureds were not living at the property. They were aware of that from the outset. The Rowes had insurance from State Auto for many years, first for a house in Cleveland, then for the house in Oberlin where they still live. And in 2006, they purchased this home and elected to insure it with State Auto. They truthfully answered a question whether they owned, occupied, or rented another residence. State Auto has been continuously aware since 2006 that the Rowes were not living at that property, and they have never lived at that property even until today. So that was made very clear to their agent and to State Auto. Now, unfortunately, we have a very thin record because I have never been permitted to conduct depositions of any State Auto personnel. And I don't know why, because my motion to compel has been pending for nearly 2 years. So there's some things the trial court clearly has not addressed. And as counsel indicated, he proceeded to grant summary judgment over my objection and over my request for a 56F extension in order to conduct those depositions. So that issue is not before the court. I won't talk about the summary judgment any further. But
That's
you're muted, Your Honor. I can't hear you, Your Honor.
You're muted, Judge Carr.
I know,
There.
I'm just slow in the draw.
Okay.
Sorry. I was just going to say, though, the whole point, though, we're here just in regard to
Right.
Whether these documents were privileged, because this is an interlocutory appeal.
Right. Thank you, Your Honor. And I would say in terms of the facts and the record, the record's not as thin as counsel indicates because, unfortunately, because of the thinness of the record, I essentially had to quote verbatim from some of my own filings in the trial court. And I think that was adequately stated in the statement of the facts where those facts came from. So it is a part of the trial court record. Now, granted, it's not supported by citations to deposition testimony because we haven't conducted those, but the record is what the record is. And I'm pretty confident that the statements I made in the statement of the facts are documented in the record. Okay, so in terms of the argument, I actually don't think we have a final appealable order here, and I've been clear on that. I don't understand how the same order can be both a final appealable order and not a final appealable order. In other words, Mr. Gallagher is able to appeal the trial court's determination, direction to order production of privileged documents, which the court did not order, by the way. The court never ordered production of the claim file, and we are not entitled to contest that same ruling, which is essentially, it's essentially the same issue. So first,
Counsel, I want to make sure I'm on the same page with you. It
Yes, Your
seems
Honor.
like what the trial court did was a little inconsistent. It said there's no discoverable issue here, that these documents are not discoverable. They don't have to be turned over, but then says I'm going to give a quick eyes only review to the plaintiff. So isn't that inconsistent?
I agree, Your Honor, it is inconsistent, and I don't think both parts of that can stand. I don't think there's a final appealable order for 2 reasons. I don't think either A or B of the provisional remedy is satisfied. First of all, there's no privilege here.
Well, the privilege comes, it only has to be a colorable issue of privilege, doesn't it, to get into a final appealable order. And then we look at whether there is or there isn't privilege. But I guess I'm a little still confused with what I'm characterizing as an inconsistent ruling in regard to the fact that the trial court said no discoverable materials, but then said plaintiff can look at it. So we do have basically a release of potentially privileged or confidential information?
We arguably, yes, although not necessarily privileged, and this has been discussed in the brief why the privilege doesn't apply, but the court's determination that no legal basis for said file being discoverable. What would be the basis for that ruling? Did the court find a privilege? Well, the order doesn't say that. Does the court say confidential? Confidential is not privileged. But what would be the basis? Because there is a bad faith claim, as counsel acknowledges. And what he hasn't mentioned is there's also an abuse of process claim still pending. And, you know, there's documents in the claim file related to that. And counsel says the claim was denied on July 12, 2017. And maybe it was, and maybe it wasn't. But everything that happened related to the abuse of process claim occurred after the denial. It all happened during the initial lawsuit. But let me speak to his claim that there was a denial on July 12, 2017. And what I would say is something may be familiar to members of the court. It's the parable of the two sons. So a vineyard owner had two sons, and he tells the first one to go out and work in the garden. The son says no, and then he does it anyway. Tells the second son, go out and work in the garden. The second son says yes, and then he doesn't do it. So which one of these two sons did the will of the father? Well, the answer is the first one. Even though he said no, he still did the will of the father after that. And so I would say that's not a denial on July 12, 2017, because when suit was eventually filed, first they did nothing. Then they sent another reservation of rights letter, which didn't say they would defend, but then they did defend it. And then State Auto sent another letter saying, you know, we offered to defend it, which was not a reservation of rights letter. And then Attorney Gallagher sent a third reservation of rights letter because the first one was before the denial. And then they wound up defending it. And honestly, Don Anspaugh did a good job. We have no complaints with his defense of the clients. And you know, got a good result. But unfortunately, there were damages caused by the delay in the defense. There were damages caused by State Auto not communicating with the insureds the fact that they intended to settle. So all along, they're saying, we're not going to provide coverage, we're not going to provide coverage. And then boom, they pay the policy limits and they think they're done with it. But the Suver case says, no, you can't avoid bad faith simply by paying the claim. And then there's the conduct of State Auto, and I hate to say it, but their attorney, James Gallagher, which is the basis for the abuse of process claim. He's a distinguished attorney, and I have no issues with him personally, but I do have some issues with the conduct in this case, and I believe that's tortious, and we have a claim for that. So all those issues are part of the claim file, and all of those issues arise after July 12, 2017. The other thing related to the bad faith claim, which maybe arises before that, you know, State Auto had an opinion letter from their own in-house counsel that rejected every single ground for denial, including the babysitting business, on the grounds that the Rowes were, what he said was, the Rowes are not living at the West Road, Pittsfield Township property. That's the only ground he could see. 6 months later, their investigators said, you know, you may draw a bad faith claim from attorney Mike Wilson, who was counsel at the time, if you deny this, because clearly you knew that they were not living on the property. So, you know, all of this is before they actually denied the claim, supposedly on July 12, 2017. So there's issues there. I don't know how you say that we can't access the claim file. And I don't know how there'd be an attorney-client privilege, quite honestly. I mean, first of all, the privilege applies to the testimony of the attorney, so not the testimony of the client. The attorney may not testify as to communications or the attorney's thought process, but these are communications in the insurance company's claim file. Why can't they testify? And quite honestly, I've given you cases from other states, and I apologize for the deficient citation. The Curtis Park case, I gave the Lexus citation, but it's out of Colorado. The U.S. District Court in Colorado, that's last year, 2021. We have the Supreme Court of Mississippi, 2020, and the Western District of Washington, 2020. And they all say when the lawyer is performing non-legal tasks such as writing denial letters or reservation of rights letters, as Mr. Gallagher did, that is not an attorney-client task, and there's no privilege. So, I mean, if somebody wants me to pay me my legal rate to mow their lawn, I'm happy to do that. I think that's a pretty good rate to mow the lawn, but there's no attorney-client relationship there. And that's essentially what Mr. Gallagher was doing. He was performing a non-attorney task for the benefit of his client, but there's no privilege. The crime fraud exception has been briefed. That's pretty well documented here. This court's own cases are pretty clear on that. And I would say finally, State Auto waived any residence requirement, the residence requirement in the policy, and that's Rowe through Medmark, which is a case from this court. When the insurer induces reliance by the insured, the insurer can expand coverage that way. In this particular case, State Auto issued the policy knowing that the insureds never lived at that property, and they still haven't. The business operated on the property, and this hasn't been clearly said by my opponent. There is not a denial for a business operated on the policy or a daycare business operated on the policy. The denial is for a business operated by an insured. The Zendas were not insureds. They did not live in the same household as the policyholders, and thus they did not qualify as insureds. That is actually part of our bad faith claim. We believe that State Auto defended the Zendas in bad faith. Nobody asked them to do this. Nobody ever claimed they were insureds, solely to facilitate their own position on the coverage issue with regard to the Rowes. The Zendas were not insureds. There was no colorable question that they were insureds. They never lived in their parents' house, at least at the property that was insured. So with that, I would thank the court for its indulgence.
Any questions, Judge Carr or Judge Callahan? All right, thank you very much, Attorney Carr. 2 minutes and 32 seconds, Attorney Gallagher.
Hopefully that'll be enough. Judge, in responding to some of the points raised by Attorney Carr, where he indicates that State Auto was fully aware that the Rowes were not living in that other property. There's nothing in the record about that, and there's no information about that either. The State Auto was aware at some point that they own two properties, but whether they lived in both properties or didn't live in both properties is completely different, and there's no indication, and there's no citation to the record that they knew that. So that's another unverified fact that's nowhere in the record being documented. When it comes to discovery, the Boone versus Van Lighter case, Supreme Court is very clear. It says you can get claim file materials up to the time there's been the denial. There was a denial in July of 2017, and that's the breakpoint that State Auto used for production. When it comes for the abusive process claim that is attempted being asserted against me, State Auto, when they first filed an answer to the original deck action, the Rowes had filed, they quoted an endorsement they had called the abuse and molestation endorsement. And the reason why is because the endorsement said there is no coverage to the extent that there has been abuse. In this case, there was a babysitter that left 3 2-year-olds in a backyard with a swimming pool unsupervised for enough period of time for them to crawl under a ladder, crawl into a pool, and drown. According to RC 2151.31, neglect can in fact be abuse. This court rendered a decision in 2019 in the case of N. Ray CGS, where you indicated an abused child includes one for whom a person creates a substantial risk of harm to the child by violating a duty of care. And that was the basis for why we quoted that policy exclusion as being potentially applicable when the Rowes were being sued in part for the wrongful death of this child. And that is a neglect claim. And then finally, I still don't understand. State Auto did in fact obtain a full and final release of all wrongful death claims and also of the brain injury claim for the other child, not only on behalf of the Rowes, But on behalf of the Zendas who were living on the property, the Rowe seemed to think it was bad faith for us to get rid of a huge financial exposure to their daughter. I honestly don't understand it. But for purposes of today, what we're here for is the fact that the trial court made an express ruling, which is non-appealable, that there was no legal basis at all for the file being discoverable after reviewing the file contents and my privilege log, where I alleged privilege. The only error in this case is where, after making such a finding, the court then ordered me to allow opposing counsel to look at it anyway. And that, unfortunately, is error on its face.
All right, thank you both for your arguments here today. Court will take the matter under advisement, issue a decision in due course. Each of you will receive a copy of the decision on the day it is released, and the decisions are also posted on the Ohio Supreme Court's website. We really appreciate hearing from you both, and we, on behalf of Judge Carr and Judge Callahan, thank you again for your presentations.
Thank you, Your Honors.
Thank you,
Have a good
Judge.
day.